Good afternoon, everyone. My name is Darren Sall. I'm here today as your employment and disability lawyer for Samfiru and Tumarkin's question and answer session. I'm here for the next 28 to 30 minutes or so to answer any and all of your questions related to employment law, disability law, anything you've wanted to know about these areas. Please hop on, ask your questions. Don't be shy. There's no question too short, and there's almost no question too long. I'm here to give you information on situations you may be experiencing, that you may have experienced in the past, and things you may be worried about experiencing in the future. And to that point as well, you can feel free throughout the broadcast today. We'll have contact details and numbers put up on the screen to contact us. But if you are shy and perhaps have some personal information you don't want to share online with everyone else, totally fine. You can reach out to us at employmentlawyer.ca. You can go to our website. You can either click on my link, any of my colleagues. I practice primarily in BC. We have offices in BC, Alberta, and Ontario. For disability, we help people across the country. Feel free to reach out to any of us. We have a wonderful intake team who's always there, ready to take your calls, get back to you promptly, and look to give you any assistance and any help that you do require with any of your issues. While we wait for some questions to come rolling in today, I want to let everyone know that there is another session tomorrow. It's 1 p.m. Eastern time. It's with Samfiru, the employment lawyer himself. And that will be broadcasted, like I said, 1 p.m. Eastern time. Again, he's here to answer all of your employment questions. So tune in, hit like and subscribe if you find this useful today, or if you found any of the other sessions useful. Hit like and subscribe. Tell your friends and family. Our goal is to get information out there. To arm employees and everyone with the information that they need to know, because employment's important. It is a key cornerstone of our society, of our lives, and it's something that you should have information on. While we're waiting for the questions to kind of roll in here, I want to hit a couple topics that have kind of come up recently. The hot button topic, over the last 2 years has been COVID, and now you see all these layoffs happening, primarily in the tech industry. I think Alphabet, the parent company of Google and YouTube, has announced layoffs in 2023. And this goes with, the layoffs that were announced by places like Shopify, just a ton of other tech companies, in BC and in some U.S. parent companies that have done the same thing. Microsoft, we've seen those as well. And so I'm going to talk a bit about your rights in the case of, an economic downturn, and in your rights in the case where you've got employers who are laying off, 30, 40, 50, 60% of their staff from single locations. Because there are enhanced severance requirements there. And so why don't we start with that? When you're looking in a situation where, say you're in an office of 100 people and 50 or 60% of those people are laid off, you would qualify in BC for what's called a group termination. And a group termination, what it does is it imposes an additional requirement on the employer for enhanced notice in the case of severance. And so what that could look like is an additional 9 weeks of notice of your termination, an additional 12 weeks of notice. And part of this is because you have so many people who are being laid off from a single position and a single sector, field, and whatnot. And so there's going to be likely higher competition for jobs and whatnot. I mean, there's a lot of things that go into determining what severance, what the purpose of severance is designed to do. And at a base level, it's to bridge you from one employment to the next. It's to allow you to go from one employment to the next employment at your same level of income. And both the government and the courts have instituted requirements that employers are required to meet in that respect. And so, like I said, when you're in a group termination situation, there are several, in some cases, there are several other requirements that the employer does have to meet. There are very fact-specific issues that may come up. We do have a ton of blogs and resources on our website. You can go to employmentlawyer.ca. We have a media and a blog section. There's a mass termination article that was written on there. I think I actually authored that one, and you can read there, and it gives you kind of the do's and don'ts, the tips, and the kind of fast facts, if you will, on group termination. So you have a bit of a primer in that if that does come to pass. And kind of flowing from that, we've also got severance in an economic downturn. And a lot of people will think, well, if the economy is bad and I'm getting laid off because the economy is bad, or I'm getting fired because the economy is bad, maybe my employer doesn't have to pay me severance. And so that's incorrect. Your employer does have to pay you severance. The prevailing economic conditions don't impact your employer's requirement to pay you severance. In fact, they may have to pay you more severance. Part of the analysis into what is reasonable severance or reasonable notice also looks at your ability to find replacement employment. Naturally, in an economic downturn, for example, the 2008 global financial crisis or COVID, we saw increases in notice periods there because the courts recognized that, well, in this period, we've got just a ton of layoffs. We've got competition for positions. We also have a scarcity of positions. You have a competition for those few positions that are left, and you have a scarcity of positions as well, because in an economic downturn, people aren't spending money, businesses aren't typically expanding, most of them at least, and this causes a real hardship on people to find work, and a hardship on employers to employ people, to pay wages and whatnot. But that still doesn't absolve them of their requirement. It doesn't absolve the employer of their requirement to provide you with severance as an employee. That is part of their requirement. Being employers and as an employee, it's part of your right to receive severance if you're terminated. And so we got a couple questions rolling in, so let's shift gears over here. And we got a question from Lisa on Facebook. Lisa asks, can an employer let you go from your position due to a disability? Would you still be owed severance if so? So Lisa, we're going to break this up into kind of two chunks here. Can your employer let you go from your position due to a disability? Your employer can let you go from your position for any reason whatsoever at all, provided it's not a discriminatory reason. There are rights enumerated in the employment in the human rights and human rights legislation of each province. Your question is asking if they can let you go due to a disability. No. If they do, it's not going to stop them from firing you, right? If they do let you go due to that, you are still owed severance. But more than that, you're going to be entitled to human rights damages. You'll have a claim for human rights based on discrimination due to your disability. If it's physical or a mental malady or cognitive or something like that, and they let you go for that specific reason, then that would ground a claim in discrimination. So it's something to be very aware of. You are owed severance in that situation, and like I said, you're also entitled to human rights damages, injury to dignity damages. It is definitely something to pursue. Lisa, if that's something that's happened to you or someone that you know, please do reach out, speak to an employment lawyer, and either us or we can always help you. Employmentlawyer.ca. You can go on, depending on what province you're in. You can reach out to our intake team. They'll set you up with a consultation with one of our employment lawyers, and we'll be able to get you or whoever is suffering from this tragic situation the help that they deserve. All right, Lisa, hopefully that answers your question. If you have more specific details or questions you'd like to ask, please feel free to do so. We got another question here off YouTube. It's Ashley Burrows. Ashley asks, what if your employer includes a 2-month notice period before you are let go? Is that considered enough to prevent them from paying severance? So, Ashley, it's a great question. It's a common misconception that severance has to be either notice or a payment. It doesn't. It can be either, or it can be both. So what the key thing severance looks at is reasonable notice of termination. And sometimes where that's not provided, your employer provides you pay in lieu of that notice. And that's really to give you the effect of the notice, as if you were given, say, 2 months in this case. Whether they paid you or let you know, you still are getting wages for those 2 months. What determines what reasonable severance is a number of factors. Ranging from prevailing economic conditions to your position, the length of your position, so your seniority in that position, how long your tenure is with that company, the specific position you have. If it's a niche field that is typically difficult to find work in, that can affect how much severance you get. Scaling you upwards, perhaps, if jobs are very difficult to come by. Your employer can also give you notice. So let's say, for example, your severance entitlement is 12 months, and your employer gives you 6 months notice and says, we're going to fire you in 6 months. It's January 1st. As of June 1st, your employment is terminated. There's your 6 months of notice, or June 31st or whatever. Here's your 6 months of notice. That's all you're entitled to. We're not going to pay you anymore. Provided you don't have an employment contract with an enforceable termination clause, you would be entitled to potentially another 6, maybe even 8 months of notice on top of that. And that would be likely payments in lieu of notice, as they've only given you the 6 months. So if that has happened to you, if you've been given a certain amount of notice from your employer says to you, hey, you're going to be let go in 2 months, or you're going to be let go on this day, please contact us. And I mean, that's something else that you should also be aware of as well, is notice of a termination. In order to be effective as severance, it has to be a definite date. It can't be your employer saying, hey, Ashley, we're going to terminate you in a couple months here. We'll let you know when that is. Until you've gotten notice of when that date is, they have to come at you with a very specific date. So, Ashley, your employment is over come June 23rd. That would be able to be used as effective severance, or at least considered as partial effective severance, depending on what your entitlement is. If your entitlement is only 2 months and they provide you 2 months notice, if they say it's January 24th, if they say your termination is March 24th, then that may be sufficient severance for you if your entitlement is only 2 months. And now, Ashley, we also asked, how does a notice period help with the loss of a job if you still have to work and cannot find a new position very easily? So that's a great question as well. And part of that is, there's an obligation on every employee once they're terminated, whether it's working notice or not, to mitigate. And so that means reduce their damages. In the context of an employment relationship, as you've hit the nail on the head here, that's finding new work. Part of that is your employer is supposed to provide you some time to find additional work, right? And to field calls, to maybe go for interviews. If they want to take advantage of that, if they want to say, well, you haven't done enough to find new work, and they want to kind of claim for that period, in my view, they've got to provide you some kind of time. They can't say you need to work exclusively for us, and you cannot go on any interviews, and you cannot, try to find work, or you can't do any of that during business hours, and then say, well, you didn't do enough to find work. Right. Part of mitigating your damages is being able to actually go out and find new work, to go on interviews, and if the employer wants to take advantage of that, because mitigation, in the sense of a legal claim, it's a defense. They have to prove that they shouldn't have to pay you your owed severance, or at least as much of your severance as you're owed, because you didn't do enough to reduce your damages. You didn't do enough to find work. And in my view, I've seen this before, and I've dealt with this before, where the employer said that. I mean, my response is always, well, you remove their ability to do that, and so you can't have your cake and eat it too. In this sense, Mr. Employer, you can't say, well, you should have done more to find work, but I actively prevented you from finding work. And so I think that's more of a reasonableness kind of standard that you work out with your employer to say, okay, I understand you're giving me, say, 2 months notice in the example you've given, Ashley. How do you propose we deal with, and I would do this all in writing, how do you propose we deal with job interviews I may have? How do you propose we deal with job search time? Like, you can do it after work, but are they going to give you any time to field calls and stuff during work? And so I would kind of set that out just in the hopes that you have a reasonable employer who wants to be good to you and wants to not leave you in the lurch, and will permit you that time to obviously still do your work for them because they're still paying you, but also give you a little bit of flexibility in order to find new work. And part of that may be, well, if I do take another job, I'll do my best to make sure I give you 2 weeks of notice, something like that, or I'll do my best to finish the working notice period. So I think some of this just comes with talking with your employer. And if you have questions about what that could look like, how to approach that, still you can always give us a call as well. We're more than happy to weigh in and have a chat with anyone about this. All right, so Ashley, I hope that answers your question. And if not, feel free, I think, to call in if you've got a specific situation. It seems like this might be something that's a little specific to you. And if that's the case, reach out. More than happy to chat with you about it. And so we have a question from Reddit from Dash. Dash asks, my friend was just let go from his company for having different values. He'd worked there for 5 years and was only given 2 weeks severance. The employer then held a meeting where they made a lot of disparaging comments about him to the other staff. Is there any value in having him speak to a lawyer? So Dash, that's a great question. If you want to have your friend reach out, I think my QR code just popped up on the screen. You can scan that and have your friend reach out to me. Short answer, yes. I think in every situation, we do free consults all the time. You don't lose anything by calling. You may gain some information, or at worst, if there's nothing we can do, you've at least satisfied yourself that you've gone the distance. You've done what you could. You investigated what you could for your situation. Here, just from without knowing more specifics on the employment contract and whether or not there's termination clauses or the character of your friend's employment, Dash, it seems like, given the length he's worked there, the employment standards minimum severance wouldn't be met by 2 weeks. So likely he's owed more than that, and the employer's in breach of statute, potentially there. If they're making disparaging comments about him, depending on the effect of those comments and whatnot, they may pose, actionable wrongs in and of themselves for things like defamation or whatnot. But I think, bad faith would definitely be rearing its head if this is the way the employer is handling the termination. Being terminated for having different values, provided it's not a protected ground, like you're not voicing, let's say, like religious beliefs, like you're talking about your religion. Your employer comes up and says, that's a bunch of hooey, you're so and so religion, I'm firing you because of that. Then you'd have, you'd still be entitled to severance, but you'd have a human rights claim as well. So I think, the context here of having different values would have to be explored a little bit, as that seems to form the underpinning of your friend's termination. So I would definitely say there is very much value in having your friend speak to a lawyer. Dash, have them reach out. Have them reach out. I'm happy to speak with them if they're in BC. Or even Alberta. If they're in Ontario, reach out to our intake team, employmentlawyer.ca. You can go on our website, speak to our intake team, and they'll set them up with someone who will be able to help them navigate the situation. Hopefully that answers your question, Dash. Another question through YouTube. It's Working Bulldogs. I like the name. And so Bulldogs asks, I read a few weeks ago about someone who appealed an EI denial all the way up to the top, and she won. The tribunal ruled declining the vaccine was not misconduct. Have you covered this in past videos? I'm curious if that ruling sets precedent. So, Bulldog, that's a great kind of question to ask. That kind of hits on that whole COVID thing I was talking about at the beginning, where that's been the hot button topic, and we're still dealing with the aftermaths of that. And so what Bulldog's asking about, just for anyone who's unaware, is that the government had put in a directive that anyone who was released from employment or was placed on an unpaid leave due to failing to adhere to an employer's vaccination mandate would be denied EI. And typically in cases where you're fired for cause or whatnot, you won't get access to EI. And so what Bulldog is talking about is a woman who actually appealed this EI decision all the way to the Social Security Tribunal, and the denial was overturned, and she was awarded her EI in arrears, so it was backdated, and I believe she was given a lump sum on that basis, and so this sets precedent for the Social Security's Tribunal. I think if you were in a situation where you qualified for EI and you're still within the appeals period and you meet those same conditions as that woman did, it was due to a vaccination issue, then you may want to appeal. And I know we've done some of that work. So if you have questions about that, we can definitely put you in touch with someone in our Vancouver or Ontario offices. But I think, based on their ruling, as long as you meet the same kind of conditions, I suspect yours would be overturned as well. Anyone else's who fits those same conditions as that case would also be overturned. I mean, it's not an area that we practice in, or that I practice in at least. And so I'm not super familiar with the inner workings of it. There are people in our office who have dealt with the tribunal, and even if you reached out to me, I'd be happy to put you in contact with them, and they'd be able to potentially assist you with that. As far as setting a precedent for court actions, no. The court may view it as something persuasive maybe to review, but the courts set their own precedents. There have already been some decisions that have come out on the whole topic of vaccines, and whether or not it's, the misconduct issue itself hasn't been directly tackled, but at least in BC, but there is decisions through labor boards which have dealt with this and whatnot. The Social Security Tribunal and the EI qualification process and whatnot, entitlement process is a kind of a beast unto itself. But the courts may look at that and hopefully revise some of their rulings or views moving forward in similar cases. And as far as us covering this in past videos, Bulldogs, I'm not certain. I haven't personally. But I'm unsure if any of my colleagues have. But I mean, you can feel free to attend any of the other videos. Someone may have a different opinion, and then you can definitely hop on and ask your question to someone else as well. But I don't think this has been covered previously. The decision is relatively new. Okay, we have a question from Joe on YouTube. And so Joe asks, my employer does not pay out proper holiday pay or overtime. They have instead offered to give gift cards. Can they do this? So generally, Joe, no, they can't. There's employment standards legislation. There's some decisions from the Employment Standards Tribunal, which has impacted the ability of employers to do this. There were some cases where certain employment standards benefits and certain pay was provided in the form of gift cards or something else, and the Employment Standards Tribunals have said no, this is not allowed. In cases like this, Joe, so whether or not you're entitled to, so overtime, we're going to separate that for a moment because there's certain qualifications there with people like managers, or if you've never been paid overtime before, your particular employment situation. In BC, at least, you may not have a right to that overtime. But proper holiday pay is something you're statutorily guaranteed. There's actually grounds on which they must pay it. They must be accrued, and it must be done and paid out in a specific way. And so if you are in a situation where this is the case, I would advise you can contact us. I would definitely advise that you contact the Employment Standards Branch immediately. You only got 6 months from the date of a breach to file a complaint with the Employment Standards Branch. And so I tell people, the minute you find out about these, you contact them right away. 6 months seems like a long time, but it's really not. And there are a number of issues that can pop up with that, with the dates and whatnot and the timings. And so I would say contact Employment Standards right away if that's your case, and give them a detailed explanation. And if you guys ever have questions in between these videos, or on the weekends or in the evenings or whatnot, I mean, I know people don't probably sit around thinking about employment questions, but depending on your situation, it may be something you're dealing with, or like we had earlier today, a friend is dealing with from Dash. Email us, help@employmentlawyer.ca. That's help@employmentlawyer.ca. Send us an email, and someone will get back to you. And they'll either put you in contact with someone in our office, or they'll be able to perhaps answer your inquiry, in a quick email. All right. And we've got a question here from Gene Smith. Gene Smith on YouTube asks, how long is an employer allowed to place you on a layoff for? My sister has been told she may have to be put on a layoff for 1 to 2 months. So, Gene, there's a couple issues around this. And so unless there's a contractual right for your employer to, or for your sister's employer to place her on a layoff, then she can claim what's called a constructive dismissal. For being placed on a layoff. Removing her pay and ability to work is something that's a very serious matter, and something that employers just can't do unless they've bargained for that in their contract. And so I always tell people, if you have a contract in place, call us, send us a copy of the contract. Constructive dismissals, layoffs are tricky issues. There are sub issues. There's a lot of stuff that can be going on there that can impact your ability to claim a termination based on this and go for severance. And so I tell people, if you're ever faced with a situation like this, before you do anything, one, lodge an objection with your employer. Say, well, I'm not agreeing to this layoff, and then contact a lawyer right away. Have a chat about your specific situation. We'll be able to give you an assessment of what your rights are, what you may be able to do in that situation, because it is very fact-driven. There are facts that can, like I said, if you've got an employment contract that permits your employer to put you on a layoff, then you may be stuck with that. If it's a situation where you've been placed on a layoff and you've agreed to the layoff, again, you may be stuck with that. There are provisions for example, in British Columbia, in the Employment Standards Act, if you're placed on a layoff for X number of days within a certain period, 16 weeks in a 90-day period, in a 20-week period, then you are automatically deemed terminated by operation of law, which means you don't have to claim anything. You don't even have to claim the termination, but the law views your employment as terminated. Now, you could ignore that, and you could go back to work if they call you back, and that's your decision. But there are a number of permutations to this that can pop up. And so, Jean, it's a complicated question. If she's being told she has to be put on for 1 or 2 months, and she doesn't want to do that, I would say contact an employment lawyer immediately. And so we've only got a couple, 30 seconds or so left. We've got a question from Morgan here on YouTube. And Morgan, if I don't get to your full question, feel free to reach out to me offline. I'm happy to have a chat this week. If disability cases can take a year to settle, how do people afford to pay for this? Why does it take so long for these cases to settle? So we offer a number of retainer options, Morgan, and then we can chat about that. Given the specific situation, we do offer contingency options, which is you don't pay anything up front or on an ongoing basis. The fee is based on a percentage of the overall award. And again, you can scan my QR code. I'll give you my contact details. Reach out to me directly. I'm happy to chat with you about this. As far as why it takes so long for them to settle, medical cases can be very complex. Depends on your symptoms, how long they're going on for, what your prognosis could be. And so they're very specific. Some cases do settle very quick. Some cases can settle within a matter of months. Some may take years. Really depends on the specific medical situation that we're dealing with, the term of the policy. If you've got 3 years left on a policy as opposed to 20 years, it's going to look very different, as well as depending on what that prognosis is. So it looks like we are out of time. Gone a little over. I do hope I got to everyone's questions and didn't miss any. Please join me again in 2 weeks. I'll be back here to answer all your employment and disability questions. And you can join us again tomorrow at 1 p.m. Eastern time. Leo Samfiru will be on to answer all of your employment questions. All right. Have a great afternoon, everyone. Take care.